Item 3 will handle item 1 last. And so item 3 is ORA 24-0001, the minimum lot size on the reservation. And Bill, were you able to watch that public hearing?
Yes, I was.
Okay, perfect. So with that, I don't know if staff wants to reintroduce that, or we can just go into deliberations.
I don't know that staff has any additional information to add, and so if you choose to enter into deliberations, we'd be fine with that.
Okay. All right, Bill, do you want to go first, second, or third?
Let me go third because I've been away for a while.
Okay. Bruce?
This is something that I had proposed initially when we first started looking at this issue, and having the opt-out for the rezone, but in addition to that, putting a temporary hold on the minimum lot sizes from 5 acres up to 10 acres for 3 years. And that's because the tribe is in the process of developing groundwater reports that can tell us what's going on down there, give us a clearer picture. And I think that as a Board of County Commissioners should always be concerned with the citizens that are in the county, not the people who are outside the county, that protecting one's property rights includes protecting their water rights. And we know that water is a limited resource in certain parts of the county for sure. And so this is temporary so that we can get more information to hopefully make a better decision. And the tribe has agreed that 3 years should be enough time for them to provide that information. This is not a mission creep where we do something temporary with the intention of making it permanent. I have no desire to make something like this permanent. And any future board can change, they can do a rezone, they can make these things permanent, but there is no incremental step here. The board can just do it. And so from that perspective, I am for this ordinance on a temporary basis until we can get more information, hopefully good information, so we can make a good decision for the citizens in that part of the county.
Okay, thank you. I cannot support this ordinance at this time. First, we have not been presented with a water study or studies that definitively outline the water challenges on the reservation. I've heard circumstantial evidence of the water problems and have been presented with well data that indicate the majority of the wells drilled are above the 5 gallons per minute threshold for development. Second, people have a right to live on their land whether or not they have a well or municipal water. From my understanding, the city of Athol has many customers who regularly purchase thousands of gallons of water for domestic use. While not as convenient for the residents in South County to purchase water, the option exists. Third, this does nothing to control the number of wells that can be drilled if water truly is the defining reason. Fourth, there's no indication the tribe will be amenable to any development whatsoever on the reservation if this were to be passed. Fifth, property owners who purposefully bought their property with a 5-acre minimum in mind lose that prospect, and this does not protect property rights. I'm pleased with the tribe's effort to be good stewards of the reservation by conducting this water study. I will revisit this ordinance once the water study is completed and the results are presented to the BOCC for review. To make this determination now, however, would require much more compelling data-driven evidence than is available today. If by chance there are 2 votes to approve this ordinance, I strongly request the sunset be August of 2026 or as soon as the water study has been completed and reviewed by the BOCC. Bill?
Okay. Good presentation, Leslie. I think I tend to, especially after viewing the hearing, I tend to agree with what Bruce has said, because I like the idea that we have a 3-year period during which to gather well information or water information. We could make that 10 years together and would have a better outcome. But I don't think that's fair to make people wait that long. So I would support the 3 years and the 10 acres.
All right, is there a motion?
I move that we approve ORA 24-0001 for the minimum lot size on the reservation. And I believe it's already written as a 3-year expiration.
Madam Chair, Commissioner Matari, we would need to put a date in for this to begin and for this to sunset. I would, suggest potentially July 1st for the beginning date and then June 30th of 27 for the ending date. That would be 3 years.
Okay. I move that we approve ORA 24-0001, minimum lot size on the reservation of 10 acres beginning on July 1, 2024 and ending on June 30th, 2027.
I second the motion.
Bill Brooks,
Aye.
Commissioner Matari,
Aye.
Chair Duncan.
Nay. All right, now we can start our public hearing. Item 1, ORA 23-0002, and this is the exempt family division of land, and it's a continuation from May 9th, which I think was another continuation from earlier this year. If the applicant representative wanted to keep his comments very short, I'd like to try to get through some more people who have not had a chance to speak yet. And so is there anyone who signed up to speak who has not spoken on this issue at the previous hearings? Or has everyone who signed up already spoken? Okay. You've not spoken? Okay. All right. Okay, well, I'm happy to have you speak this morning, so.
Madam Chair, if it's all right, I
Put-
can address mine in rebuttal.
Okay.
And it'll be a little longer than usual rebuttal, but I can just do it rebuttal and I'll be good.
Okay, great. All right, and Mr. Hughes and Ms. Drainer, is it? Okay, is that sufficient too? Okay. Okay. Then I'll make sure that you get a chance to speak. Okay? Actually, why don't you go ahead and come up if you would like to give comments?
Listen, my dad owns the property that he's gifting to us,
Okay.
and so we actually just moved here. He's been coming to the meetings.
Okay, and likely he's spoken
Yeah.
for
and
us.
So he's probably spoken, and so I'm kind of filling in today for him. And
Okay. All right. Mary White, you've previously spoken? Okay, and I'll just mention in favor. Neil Hanch, okay, you want to? Okay, you have 3 minutes, sir.
So when I was at the last meeting.
Is your you got to push the little button on the microphone so it turns green.
The name and address, please.
Okay. Neil Hanch, 6201 Sparrowhawk.
Okay.
And so when I was at the last meeting, it was brought up that somehow it would have been unfair to people who had property that wanted to divide it, that perhaps didn't have family. And I sent an email on it, and sometimes my emails will probably be better than me speaking, but I found it to be disturbing. If someone had a 20-acre piece of property with no family, but they wanted to divide it, it would be strictly for monetary gain. And that's not what we're talking about here. We're talking about faith and family and community, and what makes a community strong. And by passing this would aid in that benefit. I heard a lot of people speaking about how they were already on the property but wanted it divided so they can keep their family intact. That's what I intend on doing, is dividing so the kids have a piece and the 2 grandkids have a piece. It's not for monetary gain. So that argument that it's unfair to people who don't have family is a mute argument. and I believe it was made by the Planning Commission. And so I think it's important for not only families, but the community to approve this.
Thank you.
Yep.
All right, Debbie Hanch is in favor, does wish to speak. You don't wish to speak? Okay. Jennifer, oh boy, say your last name for me. Okay. Okay,
Speak today. Same thing, first time I've been able to attend the meeting.
okay,
I just figured it out.
thank you. Rob Stratton in favor and spoke previously. Thank you for putting that down there. And Kevin Howard didn't say in favor or not, may wish to speak.
Just here, we're Idaho district.
Oh, okay. All right, with that, Mr. Wickman?
Commissioner Duncan, we do have some
Yes.
people on Zoom that may wish to speak that
Okay.
haven't yet. So I don't-
Okay, yeah, go ahead and ask.
For those of you that are on Zoom, if you wish to speak on this matter and have not yet spoken before, go ahead and unmute yourself. Know that anybody seems to be jumping at it. Maybe while they're thinking about it, I did want to also mention that I received an email last night from a Deborah Mitchell, just to make sure that she wanted her comments into the record. And so I'll go ahead and just read those briefly here for the board. So it says, I just found out that David is out of town. I sent this to Leslie and the board, but I do not know if they have had time to read it. Is there any way that you can add it to your comments? I'm thinking I'm the only opposition at this point. It hasn't been publicized much. So the actual context of her comment is this. How can you vote on ORA 240001, Family Division of Land on 6/26, when the public hasn't had the minutes until today? Please notice the date on this forwarded email, which, for those who can't see, was June 26th at 9:29 p.m. Additionally, on May 9th, many speakers were invited by the public, thus the numbers were very skewed and should be disregarded as unfair. Not many citizens even know what is proposed. One of my concerns has not been addressed. Who will police these divisions? It's not the title company's job, it's not the assessor's job. The complexity and long-term consequences will be costly to every taxpayer, all for the benefit of a few. Furthermore, the courts will be overworked with new cases involving disputes with surveys, chain of titles, undisclosed improvements, water rights, mortgage laws, etc. Ben Tarbutton spelled out compelling reasons to vote no on this application. Keeping Kootenai has been the vision and guide for several years. Splitting land is not preserving anything. Conservative and conservation, the two words come from the same Latin root. Please conserve Kootenai, our agricultural lands, our wildlife corridors, our children's future to be able to hunt, fish, and farm. The solution for families is simple. Put a modular home on your property and use the same well. Then, if there is a divorce or death, sell the modular as personal property. Respectfully submitted, Deborah Mitchell.
Read into the record as B 1000.
Thank you. All right, until somebody chimes in, I think we'll,
B, which thousand, does that duplicate a prior exhibit number?
from prior
Oh,
meetings.
let's go B 2000.
Okay, thank you.
Thank you.
Yes.
Good morning, Commissioners. Rand Wickman for the record, 2992 Gotham Bay Road, Harrison, Idaho. I'm here representing the applicant, Vince Hughes, as by now you all know. Quick shout out to Commissioner Brooks. Thank you for going through the extra effort to attend remotely this morning. We've been at this for a little while. I think we're 14 months into this project, and this is our, if you count the planning commission, this is our fourth, fifth, sixth hearing, somewhere in there. We've had a few. And this is or should be a relatively simple amendment. Most of your exemptions in your code are just a few sentences long, and appropriately so. This exemption started as a page and a half in length, and it's grown to 2 pages as we have modified it several times. And it's steadily become more like a modified version of your minor subdivision process than an exemption. The changes we've done so to address perceived issues from the staff and the planning commission and the county commissioners. We've received a shifting set of concerns from staff, and as we've addressed their concerns, they've come up with new concerns. Although with each new list, staff has had to reach a little further into unlikely scenarios, in my opinion. I didn't want to have to go through the staff's latest list, but I think it necessary to dispel some of these concerns. So I'm going to do this as quickly as possible. We'll start with the highway districts. That if you have staff's email from, or their list of concerns from the last hearing, there were 13 items on there. The first one on there was the highway districts. I met with them shortly after the May 9 hearing, and we discussed the amendment, and they now have a better understanding of it, in my opinion. I think they would prefer to treat all exempt divisions as subdivisions so they can review approach locations and do that before the lot is created, and also so they can charge their per lot mitigation fee. They now understand that as currently written, this amendment requires that they approve an approach permit prior to approval of the family division. And I was under the impression that addressed most of their concerns, although they still have some issues on their end to sort through and work out when we parted company. I know they are here today. They've opted not to speak. I will not pretend to try and speak for them, but I don't think we have a big issue with the highway district. Second and third on staff's list of issues are a couple of comp plan goals and policies that staff believes are contrary to this amendment. They both deal with development, and I say that in quotes. This family division is written as an exemption to your development rules, specifically intended not to be development as your code defines it. These policies were never intended to apply to exempt divisions of land in your code. Item 4 on the list, this addresses resale of newly created parcels with an issued building permit to a non-eligible person within 5-year waiting period after the lot is created. Staff wonders how to address such a situation. If the commissioners think this is a real issue, it is easy to address. Make building permits non-transferable. You could do this with just this type of property, or do it with all building permits. I think a narrowly tailored provision would be most appropriate. But I personally don't think this is a real issue, neither does my client. And so we have not proposed additional language for this, but you certainly could if you see it differently. Item 5 on the list is dealing with a situation where a family division is lawfully taken, the house gets built, and the CO gets issued. Then for one reason or another, the house is sold. Staff adds that this is something a developer might do. Yes, a developer, or anyone else for that matter, might do that. But they'd have to have qualified for a family division in the first place and gone through the initial waiting period. And unlike in Spokane County, protections exist in the draft to prevent someone from moving on to the next property and repeating the process. So this isn't a development strategy any more than putting it in your will is a development strategy. It's not very repeatable. And secondly, if this scenario did happen, per item 5 of the amendment, Kootenai County would not issue any new building permits to the property until the 5-year waiting period had lapsed. That is the very same penalty that you impose on almost all of your other code violations. What is the issue here? Item 6, proving up familial relationships. Again, if this is really a question, require a copy of the birth certificate. We're really stretching to find issues now, it seems like. Item 7, staff raises the concern about inadequate infrastructure in the fire district review. This is a non-issue because the fire district signs off on building permits before the permit is issued. If the property doesn't meet their requirements for access, the fire district doesn't sign off, no building permit is issued. No fire district review occurs prior to creation of lots under other exemptions either. And as I've said before, there are hundreds of other lots created every year under the other exemptions of your code, many times more than what you'll see under this one. Regarding access easements, which is item 8, item 3A in the proposal already requires proof, submitting proof of easements to demonstrate legal access. Item 9, staff's concerned about boundary line adjusting down below 5 acres in the ag sub and restricted residential zone. My response is to shrug my shoulders and ask, why would you care? You have a limitation on boundary line adjustments related to 20-acre parcels because without it, you can combine the exempt divisions and reconfiguration by boundary line adjustment to eke out a few more parcels. Absolutely appropriate to have it there. And it kind of depends on how much land you own, whether you could do that in the context of 20s. Similar maneuvers are unlikely with the family exemption because of the other limitations on family divisions. But again, if staff has real concerns over this issue and the board concurs, it is simple to add language to prohibit boundary line adjustments for these types of parcels, not unlike what you already have for the 20s. It doesn't seem necessary to me, but it's a simple solution. Item 10, here we talk about Spokane County, minor subdivisions, and concerns over water. To be blunt, this one seems like fear-mongering to me. We've talked about this before, but I have here a comparison of the proposed amendment I have here a comparison of the proposed amendment to the Spokane County and Bonner County regulations, and I provide this for you.
Sure.
Read into the record as B 2001.
Thank you.
And Commissioner Brooks, I apologize, I don't have the ability to get something in front of you today.
Yes, okay, thank you, Rand.
And so, as you'll see here, Spokane County has the least restrictive of the 3 different codes, far less involved than what we are proposing here. And they are a much larger jurisdiction by population than Kootenai County. It is very unlikely that Kootenai County would match Spokane County in the number of parcels created using the family division. And regarding groundwater, I hate to break it to you, but your groundwater resources report that you require for subdivisions simply does nothing to prevent future disputes over water availability. We can discuss the reasons for this at length if you'd like, but those reports do not contribute anything meaningful to the process. At the end of the day, the purpose of creating this exemption is to allow for creation of lots in very limited circumstances without the expense and time-consuming studies and reviews that you require in these other processes. Remember, these family divisions are something that you are encouraging because we want people to take care of family without the need for government to be in the middle of it. That's the purpose of this. We're almost done. Item 11, concern that this exemption unfairly benefits people with families as opposed to individuals without family, as the gentleman testified earlier. Again, we're really searching for an issue here. For starters, we have all had parents. So some may no longer be with us, but you know, we have at one time or another had parents and could have been eligible for this exemption. Secondly, have you looked at the tax code? How many tax breaks and credits are there for people with kids? Governments incentivize people to have kids in many different ways, and those without don't get those benefits. That's just the world we live in. That doesn't mean there's anything wrong with this amendment. Item 12, we have a newfound concern for protecting ag lands. As I've stated before, I think the opposite of staff's concern is true here. This family division, for those that qualify, has the potential to put Junior on a 5-acre piece of the family farm instead of a 20-acre parcel. That just saved 15 acres from being transferred out of the farm holding. The 20-acre division has done far more to fragment ag and timberlands than any other policy that Kootenai County has. If you were seriously concerned about protecting ag and timberlands, you would eliminate that exemption in your code, and you would stop a lot more, many more new lots from being created versus what this will result in. Finally, item 13, the tribe doesn't like it. I'm not sure why we feel the need to do the tribe's bidding here, but the county commissioners determine land use regulations for fee lands within the reservation, as we saw just moments ago with your previous agenda item. This amendment is just as useful on that part, in that part of the county, on the reservation, as any other, and I believe it's up to you to make those decisions. I'm kind of sorry we had to go through that exercise, but I will wrap up here. In our numerous hearings, especially those in front of this hearing body, you've heard broad support for this amendment from the public. Interestingly, there has been almost no opposition from the public. I don't think it necessary to reiterate the many reasons we think this amendment makes sense and the benefits that this brings to Kootenai County families. I'm confident you remember those remarks. Please think back to that testimony and remember that these are real people just trying to take care of their families in whatever circumstance they happen to find themselves. They are not asking for a government handout. They're just asking for a little less government intervention so they can address their situation. I think this is good government policy. It does not focus our energy on those that are yet to come here to Kootenai County, as is so often the case with land use matters. This is a change in the code to empower those who are already here to take care of their families. And I thank you for your patience and thoughtful effort you've put into this amendment, and we would very much appreciate your approval, and I'm happy to answer any questions you might have.
Bill, do you have any questions?
I really don't. I thought that was quite thorough. Thank you, Andy.
No, I don't. Thank you.
Thank you.
Either. Bill, were you able to watch the other public hearings on this matter?
Yes, I was.
Okay, and so are you ready to deliberate today?
I am.
All right, first, second, or third, and then we'll end public testimony.
Well, I'll go first if you want.
Okay, let's get into deliberations then. Is there a motion?
Yeah, I move that we end public testimony and enter into deliberations.
I second the motion.
Commissioner Matari?
Aye.
Bill Brooks?
Aye.
Chair Duncan?
Aye. All right, Bill, you said you wanted to go first?
Yeah, I'm really happy to support this because I think the less government interference, the better. I can see people wanting to pass on some of their property to people who are related to them. I think that is the reason a lot of people come to North Idaho. I like it that this is already, in a way, in effect, in a number of jurisdictions around us, and there doesn't seem to be a lot of problem. I don't think you'll have a mad rush of developers to try to be related to people who own property that would be eligible for a split. So I think it keeps it confined. I'm very much in favor of it.
Okay, thank you. Bruce?
This is one of those ones where you sit in either chair and you can see the arguments. Having come from a personal finance background, which includes estate planning and things like that, I can very much appreciate the desire for parents to want to leave something for their children. It's a big deal, especially when you deal with estate planning, when you deal with what happens after the parents pass, how oftentimes the children fight. It breaks families apart. So it's nice to be able to establish those plans beforehand. I have a tremendous appreciation for that. On the other side, we look at Idaho, and from the outside looking in, there's this idea that Idaho is a very free state. It's very pro-property rights. There's lots of things that we can do, and that's great, and that's what drives people to want to come to Idaho after living in other states that are highly restrictive. The thing about it is that we do have a system in place in Idaho, and as someone who came into this state a little over a decade ago, I've learned that, and I've learned it even more so as a county commissioner. There is a system in place, and we always have to be careful when people are asking us to make exceptions. And as a county commissioner, we are asked, even as recently as earlier this week, to make an exception to policy, to give something extra to one particular group that the rest of the group will not get. And my fear with that sometimes is that when we make exceptions, at some point, what's the point of having policy? Because we make so many exceptions, we've kind of slashed it up into an unrecognizable form. And many people could argue that is the way our Constitution is today. It's been death by 1,000 cuts. Many of the rights that we have in the Bill of Rights have been eroded over time because we've allowed exceptions. An exception and an exception. I would like to find a way where we could do this. What I heard from many people who spoke was that they were in the situation where it cost money to subdivide, but the child couldn't get a loan to build and to pay for these expenses because the lot hadn't been established yet. And no bank is going to lend on a parent's lot that'll be subdivided later. And so I would like to find a way where we could maintain some integrity of the system for the surrounding community, some of the requirements that we have in the subdivision process to ensure continuity, to ensure land use is compatible within the zoning and so forth in that particular area. But allow the landowner to subdivide and be able to give the land immediately to their kids. So I would like to look at something where we shift some of those requirements from the subdivision process and shift them over to the building permit process for these lots that are subdivided using the family exemption division of land process. So that way they can get a loan, they can begin the construction process, but the community as a whole, we're still attempting to follow the system that we have developed for land use, not only in the county, but it's also at the state level too. Because if we just bypass that completely, at some point, as this county continues to grow, there will be more and more people buying land, more and more people subdividing, and potentially have an adverse effect on those that already live here. And I think that's a duty of ours to look out for that. And so I would be completely for this if we could find a way where we could shift some of those requirements, whether it's wetland delineation, groundwater quality report, and you know, there are some good points here. I mean, we heard that the groundwater quality reports really, they're worthless. Well, if they're worthless, why do we have them? Why are we not talking about getting rid of them? And the question for me is, why were they put in there? And usually they're put in there for a reason. And so they may not be that good, but it is better than nothing, at least for right now, to ensure that new development doesn't cause immense expense of having to drill a new well because the well went dry, which had been a good well for the last 50 to 100 years. But it went dry after a bunch of homes went in. So I would argue that if it is that worthless, we should be talking about getting rid of it. And if it's not worthless, then we need to keep it because it's better than nothing. When we talk about subdividing and money, by virtue of subdividing your property, you are enhancing its value. You are adding a building site to that lot. Where a 100-acre piece has one building site, 5 20-acre pieces have 5 building sites. 5 20-acre lots are worth more than one 100-acre lot. They just are. So there is a monetary benefit here. And, tax policy, we want to use tax policy to incent the behavior that we want. Having kids is a good thing for society, and so, of course, they offer tax benefits for kids. If you don't have them, then you're not contributing to the next generation. So I would like for us to find a way with community development where we could maintain the integrity of some of the more important points in the subdivision process. And some of those include, like I said, the groundwater report, a title report that can be had after the land has been subdivided so that it can be sold without any question about the title. Site disturbance analysis on slopes. We have this in place right now. If the slope is greater than 15%, there are additional considerations that have to be made by someone building a home there. And we would, of course, limit it to 1 per landowner, entity, or married couple to subdivide the land for their children so they can be there. And I think having children close by to be able to take care of the parents in their older age is extremely important. It is immensely costly to put your parents into a home or not be close by to watch them. And so this has a huge benefit, in my opinion. It's certainly something that weighs on my mind with aging parents. So I think if the board is open to looking or exploring that methodology so that people can subdivide their land specifically for their children and grandchildren so that they can get a loan to build, that we attach the requirements to the building permit for that particular lot. And I don't even care if they want to sell it immediately. They never develop it, because as long as that's attached to the lot and is disclosed in the sale, the prospective buyer knows that there are some additional extra requirements in the building permit process that may not be there under a normal lot that's been subdivided through the system that is in place. So it's a little different approach, but I think what I'm hearing from the people who want to be able to subdivide the land for their children is that they can't get a loan. They can't get a loan to build a home. That's been the biggest obstacle. And so this ought to allow them to overcome that obstacle so they can build on the family's larger lot, but still meet some of the minimum requirements that the county asks for anyone who subdivides their land. And these are just bare minimum protections for the community as a whole. And that's kind of where I stand with that.
Okay. All right, I am in favor of this. I think there's some little bit of details that needs to be worked out. And unfortunately, now I've come up with some questions for legal. So, Pat, with the exemption, I don't know anywhere in our code where you can only have one exemption. Is that something we can put in this? That you can't do an ag-free split and a family exemption and a death exemption and? Can we just make it, if you've used one exemption, that's the exemption you get for on that property? So that's one question. Building permits non-transferable, I definitely would encourage that to be put into the language of this ordinance.
What do you mean by that, just out of curiosity?
Well, for instance, if somebody were to have the family split, they apply for the building permit, then they never follow through with it,
Oh,
then it wouldn't be transferable. The new person would have to go and and reapply. And then, Ben, a property that's sloped, is that already taken into fact at the building permit process or only during division?
We do have a provision in the site disturbance regulations that if disturbance is occurring in 15% or greater, then they need to provide a geotechnical analysis
At the building permit
at the
stage?
building permit stage or site disturbance stage, whatever they're requesting.
Madam Chair, to, answer your other questions, I think we can put both of those in here if commission, if we have another vote from another commissioner. I think both of those could easily be put in the final ordinance. And otherwise, I think the version, if the board is inclined to adopt this, that it would be the one that Mr. Wickman prepared as of April 3rd, 2024, because he actually added some good language in there that hadn't been in there before, plus the two provisions that you've stated you would prefer to see have in there.
Okay. And then things like, it's up to the applicant to prove family relationship. I mean, we're going to have to require some type of.
Yes, that is,
So is that something that you do on the back end, or it has to be included in the ordinance as well?
it's already, well, it's included in the ordinance to the extent that it says familial status may be established by blood marriage, adoption, or court order.
Okay.
That would give staff the authority to request proof of that familial status, however it may have been established.
Okay. And just a comment that zoning restrictions still apply, so
Yes.
with the reservation, the new reservation overlay, that will be limited to 10-acre minimums for this family split.
Yeah, that,
So that would be a zoning.
yeah, that would be, yeah, it would have to comply with that new.
Okay,
So yes, it would be a minimum of 10 on the reservation.
all right. And then I think in here already is the legal access needs to be proven.
Yes,
Okay, and then the notice runs with the land and is recorded. Is that something that we can require recordings for our divisions, our exemptions, I'm sorry? Is that something that we can? So if I come in with my 20-acre parcel, I got 3 kids, I divide it into 4 5s, that's my one time, and
Yes.
each child only gets one time,
that's correct.
okay?
And it
So-
is recorded.
It is recorded, so it would be easy for someone to look that up and say, oh, this property, has already gone through that and it's not eligible in the future.
Yes.
In
Okay,
addition, staff would have that application process to determine compliance with this section. And therefore, we would have record of the application being made, the grantor and the grantees.
Yeah, we have the belt and the suspenders for that.
okay. Okay, fantastic. So I support this ordinance. First, finding a way to keep families in close proximity to care for each other, whether it be at the end of life or beginning, helps preserve our quality of life here in Kootenai County. Our aging population is poised to strain our services, and having caregivers living next door can alleviate that strain. It's proven the longer elderly stay in their homes, the better quality of life they experience. Second, this gives younger families a shot at home ownership where they might not get the chance without moving out of state. Ownership has many benefits, including wealth accumulation, pride in ownership, and independence. It adds stability without the worry of being evicted from a rental house or an apartment. For a median-priced home, near a quarter of that price is due to regulations and government costs, and there's a huge push in our county now for affordable housing. Third, subdivisions only make sense if the developer can sell multiple lots to turn a profit. And the family split allows people who want to remain here the opportunity without creating extra parcels to entice out-of-state migration. Fourth, the code This code amendment will likely have only a small impact based on the populations of Spokane and Bonner with this exemption and the amount of their family splits per year, not even including how Spokane is so much less requirements. I can see, 70 to 100 parcels created if you just extrapolate that data. And testimony from a local firm stated that they had 17 clients in 5 years that would have qualified for this exemption, and that was less than 4 a year for that firm. And fifth, we can always revisit this if there are quantifiable unintended consequences that arise. This is a good thing for our community. Bill, are you all right with the additional requirements that I would like added to the existing ordinance?
Yes, I think those are very reasonable.
Okay.
I have a question for Ben. Ben, given these additional requirements, how do you see that as far as, the difference between the normal subdivision process and these requirements going through the family exemption? Does that seem satisfactory from the perspective of how we look at this to ensure the managed growth within the community?
Sure, yeah, so just maybe that I could clarify on all the additions that you want, Chair Duncan. We're talking about making building permits non-transferable.
For,
The family splits.
Correct,
in perpetuity?
right.
Well, yes. So if they sell, they'll have to get a new building permit anyway if they want to build something different.
Okay. Okay.
So if they have an existing home and they sell the existing home, that's with any property in the county.
What if they start the property and
Right,
then
if they
sell it?
start the property, then sell, and the building permit, there's no CO, then the person has to reapply. The new owner would have to reapply.
Okay.
So just kind of tackling them one by one, it seems like that would adequately address the issues of, somebody starting the process and then selling it off and somebody finishing the process, they're gonna have to reapply. So I think that does an adequate job of addressing those concerns. With regards to the site disturbance regulations and, any further development that are within slopes of 15% or greater, certainly, as we had mentioned before, the subdivision process would handle that before the process is concluded to essentially demonstrate that the parcels are, have reasonable utility and livability. While this wouldn't necessarily demonstrate that they're buildable, it still on the back end would, I think, take the appropriate safeguards to make sure sediment and erosion control is handled appropriately and stormwater management. One concern, though, is that staff may or may not know if it exceeds 15% at the time of building permit and may need more information to determine. And so whether or not we want to put that on the application process up front or at the time of building permit, again, either way, I think that's something that we could handle. You'll have to remind me of the other additions that you were thinking.
I think the only other one is you get one exemption per your property. You don't get to have 3 exemptions.
Oh, I see, yeah,
For
so
the
you
single
can't
property.
exercise a free split or a large lot division exemption and then a subsequent family division exemption?
Yeah.
I don't know if that's something that we have addressed at the moment. Again, currently, the code does not prevent you from taking multiple exemptions. So for instance, if you wanted to use the large lot division exemption and then subsequently take one of those 20s and do a last will and testament type of exemption, the code doesn't prevent you from exercising multiple exempt divisions of land. Your question is, should we add something in this proposal that says if you have already qualified for some other exemption, then you do not qualify for a family division exemption? Is that what you're saying?
Well, now that you're saying that, because we already have, you can only do family exemption once in here, I think that we can address the other exemptions in the future. So for instance, if we approve this today, and effective August 1st, That gives us some time to look at some of those other exemptions and see if we can add to the code separate from this to say that you only get one exemption. Because I'm not familiar enough with all the exemptions to,
I have a question. Are you referring to one exemption for the parents or one exemption for the lot?
well, as far as I understand the family exemption, it's one exemption for the lot as far as the family split. So if I've got a 20, then I get my 4 5s. But if I die, I can't, even if I was in a different zoning, couldn't split my 5 further.
Okay. But the parents could buy another lot and then,
Nope, one per
so
person.
it's one per person, one per lot? Okay.
Yes, in the ordinance right now, it's 1 per 1. I'm sorry, ma'am, we're in deliberations, we can't take questions. So, yeah.
All right,
One
just
for
want to
one.
make sure we're clear on that,
Yeah.
you know.
Because again, some of the issues that have come up, it's like, okay, I'm gonna take my free 20 split, right? I've got 100 acres, I'm gonna take my free 20 split. Now I'm gonna go in and split, you know, based on the family split. So I wanna make sure that we're not double dipping, if that makes sense. So I think it's something that we can review in the next month.
Yeah, but typically though, if you were to take a 100-acre lot, split it up into 520s, for example, then the children would still be able to subdivide through using the same process. Or you want to attach it to the lot and just say, okay, no more family exemptions. Now, if you want to subdivide that 20 acres, which was subdivided from the 100 acres originally, you have to go through the normal subdivision process. So it's a one-time thing for that particular lot and for that particular family, or actually just lot. You just leave it at the lot, and then the family can't go out and buy another lot.
Well, but I mean, that, you have to do per family and per lot. Otherwise, the
I-
family could go out and buy another lot and do this again.
Yep.
But again, the kids are only subject, it would only happen with 8,
And-
you know, a lot of kids.
And let me emphasize too, this discussion isn't because we expect families to go out and do this.
Correct, I know.
But these are loopholes that always end up getting taken advantage of by those 1 or 2 people, and then it becomes a problem down the road. And so this is the cheapest time to have that discussion.
So again, I mean, is, Pat, that's how you read it is, if I have my property, I am one person, I divide it for my kids, they each get a free, they can purchase it from the parents, but they're receiving that benefit from the family split, whether they pay for it or not,
Right.
then that's it. They can't, you know,
Are you saying that it could not have been divided, or, you know, divided from, you're using the example 100 down to 20?
well, that's a discussion I think we need to have next. Grandfathered already, we can't go back and put that, that restriction on already. Because I think if somebody has already done that split, then they should be able to use the family split. Because they've already done it, and maybe they wouldn't have done it if the family split was available, if that makes sense.
Yeah, no, it does. So I'll just refrain from adding any language
Yes,
on that
correct.
for now. and
Correct, I
then
think we
can-
need to do way more analysis on that,
Sure.
that part of it. So,
But it do include the non-transferability of the building permit.
yes,
Okay.
Yeah, you know, thinking of it, I don't think there's any way we can stop a particular family from buying another lot and subdividing it, because you can buy land in trust, you can buy it in an LLC, then you can give it to other LLCs. Well, no, it'd have to be children, so.
correct.
So do we want to make this something that is from the parents to the kids, or from an entity controlled by the parents to the kids?
The only entity that would be allowed would be a trust.
Yeah, because it specifically says spouse, parent, child, sibling, grandparent,
Right.
or grandchild in accordance with the provision of this section.
And just below that says the parcel to be divided must be owned by an individual, married couple, or a trust in which an individual or married couple retain beneficial ownership.
Okay, and so Pat, would it make sense then that the child who got the gift of the land be precluded from receiving another gift? Because could the parents not own another trust, another plot of land in a different trust? And would they not be allowed to do that as far as
An
give the
individual-
land?
An individual may receive only one parcel created pursuant to the subsection by gift or sale. that is J2D.
Okay.
Yeah, it's up on the screen.
But what if it was put into a, well,
Nope,
we
doesn't
can't, we
matter.
can't give it to a trust, right? They
You,
can't,
you can give it to a trust, but that's still the child because they have to maintain beneficial ownership of it. So that's still that gift.
okay. Ben, I don't know if you finished.
I think,
Going
I
through.
addressed the points that Commissioner Duncan had brought up, but I don't know if you had any additional thoughts.
Well, we had a discussion a little bit, wetlands came up a little bit. Would that be looked at in the building permit process? And then, of course, how do you value the groundwater quality report? Because that, from my understanding, is in the subdivision process, not the building permit process.
Correct. Currently, we do not have any wetland code or requirements for building permit processes. That is only something that's found in the subdivision code. And so if we were to defer something like that up to the building permit side, again, the current regulations do not require delineation, buffers around wetlands unless that wetland is under the jurisdiction of another agency like the Army Corps of Engineers. But the county code does not address it at all. So again, if that is not addressed here, then it wouldn't be in the future unless the county decided to change our code in that regard. With regards to the groundwater quantity reports, the purpose of them, of course, is to demonstrate the likelihood that water is available and that it is not likely to negatively affect nearby property owners. So, to Rand's point, I mean, what we have currently in the code, it does little to demonstrate that there aren't going to be any problems. But I think to your point is that it's better than nothing in that it confirms or at least demonstrates the likelihood based on an analysis by a geologist that it's not likely to have an impact to a neighboring well.
How much are those reports? How much do they cost?
I don't know the number. I've heard a couple $1,000s.
Yeah, 2,000 to 3,000. Yeah, because then I have a little angst with that when I think it is more of a feel-good situation than an actual definitive answer. We are going to have problems or we're not, so.
Well, I don't think there's any way to give a definitive answer on this. The question is, if it doesn't matter, then why do we have it? And,
To feel good.
well, I don't know if that's,
I
why
was
did,
on the board that approved it.
so you approved it?
I don't think I did, but it was approved. I'm pretty sure since I've been here, right, Ben? Do you remember?
Oh, it's been here for, it's been here
Before
for
me?
quite a while. Yeah,
Okay.
this is something that we've required, I'm trying to think of the actual time frame as when this was established. I can't actually find
I
it.
don't know that it's that relevant
Wow.
to our conversation right now, but, yeah.
And the only other question was just on the title side, because you mentioned that. There was a title report or
Title
something that's
report
in the,
is something that will be required with this application, should it be approved. I think with the notice of family division, it says here under 3D, a title report prepared within 6 months. So that will be required as part of
okay.
the application for D.
That answers my questions. Thank you.
Sure.
All right, Bill, do you have any further questions?
I do not, but I really enjoy the discussion. Thank you.
Okay. Unless I missed something, I don't necessarily feel like some of the additions that are suggested are going to negate the intent of the ordinance. So,
What do you mean?
well, the intent of the ordinance is to make this a much easier process to get through for families. So, the way it's been presented is great. Just the little bit of addition I guess I'm just giving my brain just a little bit more time to process to make sure that I'm not missing anything else.
And of course, when you receive the ordinance in its, final form, you guys can, look at it, make sure it reflects your intent and your vote here. And, obviously, you'd let me know if you, think any changes are needed.
Okay,
So there's that also.
all right. Does someone want to make a motion?
I move that we approve ORA 23-0002, exempt family division of land with the additions that we discussed in our deliberations by the board.
I second the motion.
Bill Brooks,
Aye.
Commissioner Matari,
Aye.
Chair Duncan.
Aye. Thank you, folks. Thanks for your patience. 11:14, meeting adjourned.